You're welcome back. This is Newsfile, your most authoritative news analysis show, and on Newsfile we put Ghana first. The show is brought to you by the kindest sponsorship of Bank of Africa, strong as a group and close as a partner. It's also brought to you by Star Assurance, that is your solid partner. And MTN, welcome to the new world. MTN everywhere you go, Sasso Spray, Sasso Kumuntuntum Preko, and Wimplex 400, your one-stop Duwema for the whole family. I'm Samson Ladi Anyanini, and my guest for today, Abdul Malik Kwekubaku Jr., Editor-in-Chief of the New Crusading Guide newspaper, who is a regular panelist, the Honorable Inusa Abdullahi Husseini. He's a lawyer, he's Minister of Roads and Highways, former Minister of Lands and Natural Resources, of course, MP for Tamale Central. He's a man that from the beginning we heard, talk about this possible boundary fight getting it to the international space. Kwame Fojo is a lawyer, national coordinator for the Ghana Maritime Boundary Secretariat, and Joseph Ni Ayikwe Otu, former Attorney General of the Republic of Ghana. Gentlemen, good morning and welcome to Newsfile.
Thank you.
Thank you. Great. Mr.
Mfojo.
Mr. Mfojo, this certainly will be your first time on Newsfile?
It is. It is. Yes.
Great. And the discussion that we are going to have in respect of the maritime boundary, dispute, how does the ministry or the government itself situate that discussion in the world space? I'm talking about the international media is interested. Almost all important entities within the world are interested in knowing what this is all about and how it may play out.
Okay, I think that the most important thing to understand is that quite a bit of attention has been paid to the geopolitical aspects of the situation, the technical aspects, the legal aspects, and the economic and political implications. The particular decision to go to arbitration came as a surprise to people, and that, I'm aware, has occasioned quite a bit of concern. But it should be understood that it comes against a background of a parallel process. Negotiations on the one hand by the government of Ghana through the Ghana Boundary Commission and its technical team, and on the other hand, the other aspect, preparing for a possible transition to arbitration/litigation through the Maritime Boundary Secretariat. Now, this have been in parallel, cooperative, overlapping, interlocking, and because the Maritime Boundary Secretariat aspect of it has been relatively quiet, people have not been aware that we have actually been looking at these things from a very broad perspective. Now, Honorable Minister Husseini was in charge of the Boundary Commission, the most relevant period, so I'm sure he will have something to add on that. So we're extremely well prepared, extremely well prepared.
Right, so just hold it on there for me. We'll get into the details of that particular discussion because it is very, very important. And like I say, the globe, the whole world is watching. Now, let's quickly go to the Attorney General, Marita Brewer Appiah-Oppong, who addressed the press conference and first announced that Ghana officially was going to the UN arbitral, tribunal to bring an end to these disputes.
Distance line. In recent years, Côte d'Ivoire has adopted a different approach. At stake is a large area of sea and seabed, including the natural resources they contain, vital for the economic development and well-being of both countries. The two states' overlapping claims generate uncertainty about the location of the maritime boundary and uncertainty on the part of our domestic and foreign partners regarding their rights and responsibilities. This is especially so in relation to oil and gas exploration and production. with all the consequences that that implies for future economic development. Ghana has commenced the arbitration proceedings with the desire to strengthen the relationship between the two countries by firmly and finally establishing the maritime boundary. In this way, a situation of certainty will be enhanced, offering further reassurance to Ghana's international partners in the petroleum industry that the boundary is where Ghana says it is. Now, the arbitration will proceed under Part 15 and Annex 7 of the Law of the Sea Convention. It will take place before a tribunal of 5 arbitrators, consisting of 1 appointed by each party and 3 by mutual agreement, that's between Ghana and Côte d'Ivoire. Failing such agreement, the 3 arbitrators would be appointed by the President of the International Tribunal of the Law of the Sea in Hamburg, Germany. In accordance with Article 3A of Annex 7, Ghana has appointed Judge Thomas Mensah, former President of the International Tribunal of the Law of the Sea, as a member of the tribunal. The arbitrators will decide the case by majority votes. Their decision is final and binding on the parties. Ghana estimates that the proceedings might last approximately 3 years from beginning to end. Ghana is confident that the outcome will be favorable to its long-term development and to the continuation of excellent relations with its neighbors. Ghana's decision to pursue arbitration in regard to its maritime boundary with Côte d'Ivoire is part of a national policy of achieving the final settlement of all its maritime boundaries. Pursuant to this policy, Ghana hopes to engage with its neighboring states in the east with the aim of fixing the boundaries in that area by mutual agreement. Ghana is secure in its legal position. Now, our legal team will be headed by myself as Attorney General and Minister for Justice and as agent for Ghana. I'll be working closely with Ghanaian Legal Counsel, legal team, and all relevant departments of government. We'll also be supported by a team of distinguished and highly experienced international counsel and technical experts. In particular, the international team will be led by Philip Sands, who is a Queen's Counsel and a professor of international law. He has vast experience of advocacy before the ICJ, before the International Tribunal of the Law of the Sea, and before under Annex 7 arbitration. And then we'll also be working with Mr. Martin Chamani, who's a Ghanaian and a professor of international law in Australia. They will be leading this team. And so I can assure you that the case is in good hands and that we hope to succeed at the end of this case.
Right, so you just heard the Attorney General and Minister for Justice, Marita Brew, appear upon Mrs. and she gave a press conference explaining that this is what we're going in for, and then there were questions afterwards, and one of the questions that was put to her was whether she was confident, because it appeared as if it was going to be a matter of votes, and that whichever way the majority decided, Ghana may be losing. And she stated, without any equivocation, that Ghana certainly was sure of victory. Now, I'd like to begin with the Honorable Inusa Fuseni. We have been on this platform with you before when you were leading a team, going around and making sure that there was to seek to resolve this without the need to go through this route. What happened?
Well, thank you so very much for this opportunity, and let me say that clearly Ghana started on a very strong note. Ghana relied on the African Charter and the United Nations Conventions that require pacific resolution of disputes. Ghana also saw Ivory Coast as a sister nation. We still see Ivory Coast as such. And so we thought it was important and necessary for us to engage each other at that level, set up our technical teams to see whether we could reconcile the nagging issue of the boundary demarcation between Ghana and the Republic of Ivory Coast by ourselves. Our own problem, we solve it ourselves. Now,
10 failed bilateral meetings. What couldn't you agree on?
I will not say 10 failed bilateral meetings. 10 meetings, but we did not finally resolve the dispute. But not failed at all, because we did achieve some significant milestones. One, we had set ourselves a timetable of setting up a joint boundary inspection committee to visit boundary 55. That is the boundary post between Ghana and Ivory Coast, and that is significant in determining the maritime boundary delimitation between Ghana and Ivory Coast, to determine whether the geographic coordinates were in place. I mean, whether the boundary post was where it was when the British were leaving Ghana, and also determine the geographical coordinates. And when we went, we were able to agree with the Ivorian counterparts that that is where the BP55 is, that it was never moved, that it has never been moved, and that signifies the boundary between Ghana and Ivory Coast. And that's very significant. We built consensus on that. We also agreed that we will exchange maps of our coastline with it, and so they know where our coastline starts and how it slopes and the relevant areas. They also gave us theirs. What brought in the issue, the confusion, is when we reviewed the law and practice of the UNCLOS, the International Nations Convention on the Law of the Sea, we realized that and even the law states, even the Ivorian law also recognizes that equidistance should be the principle to apply in determining maritime boundaries. Okay, and so almost all the cases favor the Ghanaian position, and so we continuously pressed. But Ivory Coast domestic legislation said equidistance and any other method that will bring equity. So somehow they have gone the second leg, not even the first leg, the second leg, and they continuously pushed us towards using the median. And the median will not give us, it's not first of all in accord with the United Nations Convention, and two, it will not properly delimit the maritime boundary between Ghana and Ivory Coast. And they had done some stimulations, and they knew exactly the outcome. And thirdly, most importantly, for a very long time, there existed between Ghana and Ivory Coast a customary maritime boundary that was respected by both parties. That customary boundary is not exactly an equidistance line. But again, both parties respected until Ivory Coast decided that they would no longer respect. I think what triggered this recent action are two. One, we had set ourselves a timeline of resolving the maritime dispute between our countries by the end of June, latest July. We are in September. Clearly, we have not been able to resolve. Three, Ivory Coast issued a letter threatening all those companies who were working around that area, and indeed claiming that part as part of the jurisdiction of Ivory Coast. I mean, clearly, as a Ghanaian and working for government, that clearly is a claim on our sovereignty. That clearly is an attack on the land of Ghana, because we have historically exercised jurisdiction over that area. And so the best way to treat any claim on the land or territory of Ghana is to use the civil Pacific means, the one civilized nations use. Go for a third-party arbitration, third-party impartial arbiter, which allows both countries to select one arbitrator each, and three to be selected jointly by them. So both of you, or both countries, determine the people to sit on the matter. And so you build around those people, because it must force you, like arbitration, to forces an invidious acceptance of the outcome, because you would have settled on which people to sit on the matter.
Right.
And like we are sitting here, if Kukubako were representing Ivory Coast, I representing Ghana, me and Abdul Malik Kukubako will then decide to choose 3 of you to also add on to. So assuming he votes for Ivory Coast and I vote for Ghana, the 3 of you who have jointly selected will determine the matter. Okay. So that's what we have done.
That's also the issue where some people express a lot of fear. But I'll get Mr. Fojo to help us to deal with that. But do I understand you to say that all 10 back and forth, what you couldn't agree was the method
to use
of determining the boundary, whether it should be equidistance or use of the median, which they suggested?
Yes.
You, Ghana, insist on equidistance.
And the Ivorian domestic legislation also recognizes equidistance,
but makes provision for additional methods. But you say they should have look forward to exhaust the first one. I see.
I'm happy you are also a lawyer.
I see.
The legislation mentions equidistance first. We thought they would have explored that option and see whether that is in accord with fairness and equity.
I see.
Before going for any other method.
Tell me, how important is this thing to us, this particular blog or this maritime zone? How important is it to our Ghanaian economy?
First of all, it is the territory of Ghana. And all the 2 world wars came because of designs of other countries on the territories of other countries. So the territory of Ghana ought to be defended and protected. That's the first thing.
Number one.
Number one. Number 2, natural resources existing on land are becoming exhausted. The search for natural resources is moving towards the sea, the uncharted waters. Indeed, it has even moved beyond the exclusive economic zone. It's going beyond the continental shelf. And so we even went to the UN and applied for an extension of our continental shelf beyond the 200 nautical miles, which was accepted. And even beyond the 200 nautical miles, there is a point that if natural resources are found, it has to come under UN jurisdiction.
Okay.
So you see, you're looking to see how much of that space is Ghana's before you can start any exploratory activities over there. People are even moving to other planets to look for mineral resources. We haven't got that capacity yet.
Okay.
But what is ours? We have warranted in agreements that we have signed with foreign companies that area they are spending huge sums of money belongs to Ghana. And Attorney General is here.
You said that area they are spending. Who are spending?
The foreign companies.
Okay, right.
And spend with ours. So we can't lose this case.
Okay, thank you very much. Let me bring Mr. Fojo back onto this now. Now, when you are at the press conference,
yes, sir.
I heard you respond to a few questions, right?
Yes, sir.
Good. Now, when you made the decision to hold a press conference, what were you seeking to achieve with it? Simply to carry Ghanaians along with you, or what else?
I think the importance of the press conference was to indicate very clearly to the Ghanaian public, the West African regional public, and everybody else that we have reached, if you like, a new turning point, that there's a shift in the way that we are looking at this issue. Previously, we'd been involved in bilateral negotiations. Now we've moved to the third-party dispute settlement level. Now, it is important, it was a symbolic, if you like, it was a symbolic positioning, and also to basically get people to reposition their thinking. So I think those are, I mean, the elements of symbolism, but also just indicating very clearly where we're coming from and what we've actually done so far. And let me just pick up on the selection of the arbitrators, because people seem to be under the impression that we'll automatically have some problems there, or at least that's, you know, in fact, your conversational point suggested that. Now, so basically the process of selection is not as arbitrary as it might seem. There's a very large body of people who are qualified to act as arbitrators in this matter. They are known, and there's a particular procedure for selecting them. I was privileged during the period that we dealt with Argentina over the matter of the Ara Libertad to actually go through this process. It took us an entire day because we went systematically through the names of a pool of people, 300, 350 people. We looked, I mean, we had the ability to look at their qualifications, their expertise, their orientation, because we all had our iPads and our whatever's there. So we Googled people, we looked at the books they'd written. So it's not a, you know, it's not just some, you know, some lotto, which is how people actually understand this.
Right.
And there are a number of considerations, which tactical and strategic considerations which go into it, which, of course, I'm not going to discuss that fully here. So we've done the work. We've been through what is in effect, courtesy of Argentina, a trial run.
Okay.
I mean, we even got to the level where we have a sense, we have a sense of how the process works. And as any experienced lawyer will tell you, half the battle is knowing how the process works. We would, if Argentina hadn't again presented itself, we would be going into this thing blind. So even you know, our particular preference for arbitration is to some degree shaped by the fact that it is an arena that we
and
feel
more importantly, the starting point for
yes.
Ghana is that the case is clear.
Oh yes, absolutely, absolutely.
But so do we understand that? But for the letters of threat that were issued to, you know, those who are exploring or working in these waters, we will still have been continuing with the, you know, negotiations that we're doing?
No, I think that, and I think that the Honorable Minister will probably also come in to further elucidate. I think it became very clear at some point in the process that we were effectively at a deadlock. And just before he moved on to another ministry, you know, he stated quite clearly that there didn't appear to be much that was going to change.
Yes, he preempted it
yes,
long ago.
Yes, and in fact, he indicated quite some time ago that, you know, and in fact, in that sense, it's not even a surprise when you look at it, because I think he even said on this show that if things didn't really turn out well after the roadmap period, June, July, we would seriously have to consider going to arbitration. What I think has come as a surprise to people is the extent of the preparation, and because, of course, people are expecting that nothing much has been done, etc., etc. And that's not the case. That is absolutely not the case at all. There's a whole backlog of archival material that has to be looked at. We have been steadily assembling it, going through it, indexing it, cataloging it, all these in an effort to present the best possible case, speed things up, so we get out of this phase, we have clear certainty, and we basically move on.
Right. Now, Mr. Ekotu, this is not a ministry you are not familiar with, and of course, many years you have practiced as a lawyer. How does it come to you first that we decided to take the first step?
Well, I think it's the aggressive exploration and what we seem to be getting from, you know, oil and gas, you know. At the end of the day, we're looking at resources. Before then, I think before Tolu made these discoveries, at the end of which we found oil in commercial quantities, I don't think that there was any aggression on anybody's part. Everybody took things in their stride. But now, with some kind of money, you know, gushing out from there, black gold, if you like, it's become more imperative that one knows exactly what one's territories are. And as he rightly pointed out, if people come to you, able within the confines of the convention and the knowledge of the law acquired, you know, come out with a decision. It's not a cha-cha game. You have to look at the evidence available before you come out with a decision. So we should trust whoever we have, you know, given this thing to go work on it for us. let them work within the convention, because I believe the tribunal set up under the convention has an exclusive jurisdiction to deal with those matters. So I don't think that we should worry our heads too much. Are we ready with the evidence? Are we able to put a team together to work on this thing for us? Which is our preference? Is it equidistance? It is media? Whatever. You go there and convince the arbitrators. Of course, if you go and appoint somebody, that person obviously would be sympathetic to your cause. What about the rest? You need to convince them, and all you need is evidence. So I believe if we put our act together, we should be able to, get something out of this thing, get this matter settled once and for all. 10 years is long enough. Perhaps in all those, period, there was no threat. Now that threat comes in, you ask yourself, what is the best option? Do you want to go to war? Are you going to prepare to go to war? So the only option is to refer this thing to a peaceful settlement. And if you look at Constitution Article 73 on international relations, this is what we are expected to do. And I think that government has taken the proper steps, the right steps, and it should be commended. We should go ahead and see how it will work out.
There are some people who have a little sense of some panic that, it might not end well. What do you say to those people?
Well, as I said, it is your duty to go and convince the arbitrators why they should rule in your favor. If you fail to do that, who do you blame? Who do you blame? In
the face of the assurances that we have a solid team, both locally and internationally, who are prosecuting this, led by the Attorney General, why should anybody, harbor any fears that we may lose this?
Oh, but why should you, if you like, believe so much in the judge? You see, at the end of the day, you are making a presentation to a team, a board, to look at the issues for you. Your duty is to put your best foot forward and hope that they will rule in your favor. Unless you have other ways and means of knowing what the decision will be, which I don't believe in. I believe in pure evidence, going there, do what is required of you, and I believe we can do that. We should forget about whatever the results are. I think we should be optimistic about whatever it is that we are doing. So long as we have the evidence, let's go present it, and let's see how
90% of the cases you prosecute in court, you go because you are so damn sure that you are right.
That is a duty of a prosecutor.
No, I'm using it to apply even to civil matters.
No, there are also 50-50 chances. There are quite a number of cases where you find that there are gray areas. There does not appear to be any precedent on the matter at all. This is the first time that anybody is going to try it. Especially in Supreme Court practice, you will be shocked that what you felt is the law, they might tell you that they are highest body, they are the highest court of the land, and this is their thinking. They are not bound by any other, thinking. So it's not always the case that you can be 100% sure that you are good. In fact, the days that you are very, very sure are the days you may even lose. You are not a judge.
Oliver Wendell Holmes. The law is nothing more than the prophecies of the court. Now, I don't know, when you sit back, you follow, monitor, listen to the pronouncements and everything else, the body language, what do you say?
I want to be very cautious, It's only in recent days that I've been trying to interrogate the issues in a more thorough manner, just to have a better understanding of what the issues are. But after reading some few documents and checking some records and all those things, I am beginning to think that, and I'm sorry if this is undiplomatic. Well, I'm not a diplomat. I think I'm a media man. I can speak my mind. I think the Ivorians are displaying a certain level of insincerity. And we should be careful. Look.
And that's diplomatic language.
We should begin to strengthen our naval and area capability. relative to that jurisdiction, the territorial jurisdiction, seized jurisdiction that we are talking about. Let's start being.
Oh, you are foreseeing the Ivorians employing methods other than the civilized methods that we are seeing?
The streak of insincerity and inconsistency that I smell worries me. Look, before discovery of oil and gas in commercial quantities, there was some level of rapport between us and them, even in conducting seismic surveys across. I have letters here, 2008, 2009, where they gave us approval to do some seismic survey. They even indicated that we could also do the same for them. I'm sure we have. I'm sure the minister would confirm. Very nice, well-written letter that shows some level of, good rapport between two neighboring states. With the discovery, even after we had done our discovery in 2007, 2008, 2009, there was still some level of rapport. But I think the discovery of these two resources, gas and oil in commercial quantities, has changed the dynamic. And let's not underestimate that some elements, because see why I'm saying this is this, 10 rounds of negotiations. The minister said it wasn't entirely a failure. I agree with him because we can see some positive aspects. But bottom line, nothing fruitful in terms of the final solution happened. And that's why we've opted for this arbitration. Fortunately, both countries are parties. And so perhaps I think is the right option. I know the era of gunboat diplomacy and all those things are gone, or is gone, hopefully. But something tells me, it's a hunch, it's an instinctive feeling that we ought to begin to ensure that we have the capability to defend our territorial sea.
Militarily, is that what you're saying?
Yes, defense-wise. We shouldn't, I'm just a journalist, so I can talk. I'm not asking the government and the appropriate authorities to go out there and speak the language I am speaking. That would be undiplomatic.
Are you
advising being indiscreet? But as a Ghanaian and as a journalist, not hindered by any of these, limitations, I say we should set up. The insincerity is so obvious. Look, they've been shifting their positions. They've been shifting the goalpost consistently. I've read some few documentation, some of which I can't make public, and it alarms me. They are not sincere. They are not seeking a solution.
Acting in bad faith.
Yes, that's the word. And I don't know where it will end. Well, we've gone to the appropriate forum. We've shown that we are a very disciplined, peace-loving country. We've chosen the right option. Or what I'm saying, right from our side here, in terms of government, the ministries, the personnel involved, they've all done a good job. I'm also very excited about the person we have chosen, Judge Thomas Mensah. He's great. You go check the literature. I mean, it's vast. It's like, quote unquote, a mini god there, an authority, an institution, if you read the literature. So that's also reassuring. And I'm hoping that if the arbitral tribunal provides the answer, both countries will abide by it. But please, let's prepare ahead of time.
Just briefly, Mr. Osei, is it the case that you decided to take the first step to preempt what Kweku suggests is potential?
Well, Kweku has filed the necessary caveats. Clearly, I cannot speak the way he has spoken. Of course. But some of the things that he has said, I share in them. I mean, some evidence we cannot make public. Clearly, this is the right step that we have taken. I mean, civilized nations take that step. And we have shown that we are a civilized nation. We've never had any designs on the territory of Ivory Coast. And so, it's good to show clearly that you want an end to this matter. I mean, litigation must end also. It's one of the principles that we learned when we were in school.
Right.
And so It must end. But let me put on record, Kuku has said something that clearly has triggered some other things in me when I was the chairman. Many Ghanaians, Kuku, in fact, I think that it's when we are threatened that our sense of nationalism is evoked. Many Ghanaians with expertise in that area have come and volunteered their service to this nation, including one time when I was traveling to Tamale at the airport. Some Ghanaian just walked up to me. I'm told you are the Minister for Lands and Natural Resources and that you're the chairman of the Ghana Boundary Commission. My name is so and so. Please, I work at X place. Some of them we can now disclose because we are in court. Get me, contact me anytime. And Mr. Fuji will tell you. Many. So it's a case that we will win. We have to win. And the bad faith and shifting of goalposts is clearly part of the agenda of Ivory Coast. You
Consistent.
see, they plan to grow at 9%, and their whole growth is hinged on the availability of gas.
I see. Now tell me, in your
there's no gas in Ivory Coast.
In your pleadings and materials that you are submitting before the arbitral tribunal, will it include all of these claim of shifting of the goalpost where you have correspondences?
Oh, America will say everything is in. Everything.
I've seen it. They've captured.
Now,
maybe I can make a little bit of a comment. I can make a little bit of a comment on that. Now, fundamentally, what we are asking the arbitral tribunal to do is to draw a single maritime boundary line between the two countries from BP 55 up until the limits of our extended continental shelf. Interestingly, and an honourable minister has actually alluded to part of this, the Ivorian submission to the UN Commission on the Limits of the Continental Shelf actually uses equidistance. So they are claiming within the 200 nautical mile exclusive zone, they are insisting that we use firstly a meridian and then a bisector, but equidistance is the position in the document that they have submitted for that last bit further out there. So inconsistencies in many different ways. And it's also important to emphasize that, okay, the threats to the petroleum companies and so on, part of the reason that they're doing that is because they want to put it on record that they object to the petroleum companies being there because they see those areas as being part of the jurisdiction of the Ivory Coast, which is fair enough. But there's a two-part approach that they've been using: threats to the petroleum companies and seemingly excellent relations at the government-to-government level. And I think that the government of Ghana, seeing this go on now for, I think, almost 3 years, because every year there is a period during which there's some tension with the petroleum companies whilst we are conducting negotiations. So, you know, there are different strategies that you deploy, and we basically decided at some point that, well, you know, maybe enough is enough, and we need now to basically get an impartial, independent, third-party group to do for us what we have not been able to do for ourselves.
Okay, now, just, yes, Kuku.
See, there is this thing here, notice issued to petroleum companies in November 2011. This is from the Republic of Cote d'Ivoire. Announcement to the oil companies in the Ivorian offshore, that's how they put it, from the Ministry of Mines and Oil and Energy. Ladies and gentlemen, CEOs and representatives of oil companies, we are repeatedly informed that oil companies continue to conduct from Ghana oil operations in Ivorian waters. The state of Cote d'Ivoire has consistently denounced these operations, invites you again to put an end to them because the resources used in this area are its exclusive property. For the exploitation of resources in this area, the state of Cote d'Ivoire has delimited 3-03 at sea in this part of the far east of the sedimentary basin. See attached map. Any company wishing to engage in any oil activity in this area must apply in order that such application is considered. As a result of the foregoing, the Directorate General of Hydrocarbons urges companies engaged in petroleum activities in the zone without permission to put an immediate end to them has the amount to theft and looting of natural resources. The state of Cote d'Ivoire has the inherent right to exercise any appropriate action to protect its rights and interests or natural resources which it will not leave unprotected. Now, the consequences, it means one of these days they could move in there with their resources, that is, I mean their naval and area resources, to try and stop some of these companies from working. These companies may have had licenses from Ghana to do those.
They issued these threats.
Before
yes.
it comes, let me tell you, it's not limited to Ghana-Ivory Coast. Our oil find is in the sea. Cocoa is spot on. Ivorians have come that far. They've come even close to Jubilee in gunboats.
Really?
But it is in the interest of the nation, because our oil is in the sea. Paris can attack. Other third parties can attack, apart from Ivory Coast. So having the resource in the sea calls for us to build a rapid response to protect that property. So you are spot on.
So you're saying,
yes.
You're saying that it was not only potential when you had not submitted the case.
I mean,
even after you have submitted the case before the arbitral tribunal.
Not before the case, and not after the case. Before the case.
Okay.
Before the case.
But
Yes.
after, you don't expect any of these things to happen.
Is that an injunction by effect of the case?
No, it's not an injunction.
No restraint?
No.
Maybe I should come in to explain first the comment made by the deputy, by the minister, and also then just say something very quickly about the injunction. Now, you see, again, it comes back to Ghana, the state of Ghana's preparedness, which, as Kwaku points out, has to be forward-looking.
Yeah.
And I think that we are aware for us to be forward-looking. Whilst I can't indicate clearly how far the forward-looking goes, I think that, it is reasonably forward-looking. Now, the particular incident, which again, it just, gives an indication of possibilities, is that at some point, in the process, the French warship, the latest high quality, the latest French warship in the system, latest, commissioned 2012. It basically goes around the world doing, the things that the Americans do, showing the flag and so on. So they came close to the Jubilee field and did a bit of a turn around the Jubilee field. They came very close. The soldiers were sunning themselves, the naval were sunning themselves on the deck, and so on and so forth. They're perfectly allowed to do this under the law of the sea, because within the exclusive economic zone, you have a right of navigation, and military vessels in particular have a right of navigation so long as they are not doing things which are threatening to the peace and security. And they were not doing anything that was in any way threatening to our peace and security.
It could be the beginning of PSYOPs.
Well, yeah, but it's one of the things, a number of things have happened over a period of time, so it's gentle, rough. And it's in that context that increasingly we started speeding up the whole business of basically making sure that we are the people who register that we went to peaceful settlement of disputes. Right. Now, where we have a bit of, if you like, a constraint on any misbehavior from the Ivorian side is that they have actually just recently come out of conflict. There's quite a few of the people within their system who are indicted in various places and so on and so forth. So in fact, we are actually, if you like, positioning ourselves morally, internationally, more strongly, etc. So that is part of the strategic response that is being made. At the end of the day, nobody is going to see us as an aggressor. The language in this document that Kwaku read suggests that we are the aggressor. But in fact, when you look at the total set of things that we're doing, we are the peace-loving people, and I think it is a good place. It is very much a good place to be. And I personally, and I'm sure the minister will also share my views on this, have been really quite pleased with the unanimity that Ghanaians have brought to this as this is the right path down which to go.
So sometime in the process, is there an avenue for you to specifically make an application to injunct anybody from coming close.
Okay.
Until the matter is finally returned.
Now, okay, yes. Now, I said I was going to explain the injunction, and I think I really need to clarify it. Now, there is not going to be an injunction placed on work in that area. Now, it's very simple. There's a very, very simple logic to it, which you understand when you view it from the point of, if you like, first principles. Both countries want economic development, right? If the Ivorians, God forbid, were to actually get all or some small proportion of this area, and the court had injuncted anybody from working, what they are going to do is they are going to find closed and capped wells, which they are now going to have to restart. Do you understand me? Mm-hmm. It doesn't make sense. It doesn't make sense in our particular situation. Maybe in the developed world where they have a lot of resources, they can afford to close down, you know. So basically, a practical tribunal, which is also what we're going for, will basically say, well, look, I mean, really, work's got to continue whilst, you know, we sort this out. If people need to give undertakings to each other to, you know, cross-compensate or sort things out, then we go ahead and we do so. So please, this suggestion out there that there's injunctions and so on and so forth.
Because in seeking an injunction, you would even be required to undertake. You would compensate.
Yeah, precisely. Yeah, precisely. So that has to be taken out of the equation altogether. It is not actually in their own interest that work stop in the area. Okay. It really is not in their interest. It is certainly not in our interest.
Okay. But is that and I think those looking at the question of injunction are not looking at stopping work. But they are looking at an injunction that preserves what is going on and stops the Ivorians from coming close.
And carrying out their threats.
Exactly.
I mean, certainly, as a matter of international law, peaceful settlement of disputes overrides any other approach to settlement of dispute. So really, if they did anything which was military, it then becomes a matter for the Security Council almost immediately. And we'll basically be going for a Security Council resolution. And again, there the international law is on our side because they have been Guyana, Suriname, to some extent, Nigeria, Cameroon, in Bakassi. There's a number of, and also Greece, Turkey, 1976, again, continental shelf. There's a number of cases where the Security Council basically said, look, there's actually peaceful settlement dispute stuff happening, so why are you actually doing this? I will get a General Assembly resolution in our favor. And in fact, should that happen, I think that it will make the chances of the Ivorians winning even less strong, precisely because, you know, arbitrators are human and they will be influenced by these kinds of
Now, let me pick your thoughts on this one finally. Security analyst Dr. Kwesi Enin, who is with the Kofi Annan Peace Training Center, is reported by Star FM to have made these comments that to be heard to say that we will win. And he said that on the back of the comment by the Attorney General. And the Attorney General's response was this, and I quote her, "We are extremely confident in our case. I don't think we will lose. Many laws support the position we have taken, so I am confident that it will go our way." Now, Dr. Enin is reported as having said, quote, "Ghana must get its loins for difficult negotiations." That one, all of you agree. Enin said, and he added that it is premature to state Ghana would win. Both parties have a good case.
Okay, maybe I should respond to that because this is, after all, the flagship current affairs program in the country. Now, do the Ivorians have a good case? The answer to that is very simply no. Why is this so? You see, there are three principal methods of doing delimitation: equidistance, the meridian method, and then the bisector method. Now, they've shifted from meridian to bisector because they realized that the meridian method that they were using was not a good one. So the bisector approach actually offered them a better option. That alone gives you some idea of, you know, if you like, the searching to build a better house or a better castle. That's one. Two, as Honorable Minister pointed out, their own domestic law requires that you look at equidistance first, and then maybe you look at something else. Then 3, the point about that I made about
and when you say look at equidistance first, the law making it
it's their own domestic law
in that nature would simply mean that until and unless you have exhausted that method, you don't look for another
they are
method.
governing themselves by their own law. The 1977, their own 1977 law actually bind themselves to consider equidistance first before any other approach.
Proceed.
Next point, the inconsistency between their practice within their claim within the 200 nautical mile zone, for which they want a bisector, which more or less goes like this, but in fact the equidistance one, which goes like that, and which is in our favor, is what they used for the continental shelf claim. Then the fact that for over 50 years they have basically respected together with us the customary practice of the current equidistance line, very, very slightly different from where the true equidistance line is. So there's 50 years of what, there's quite a few lawyers on this panel who basically would say the principle, estoppel, we would have stopped them from actually making the point that the arguments that they're making. Then when you go further, elements of their arguments which are a little bit more technical, and can justifiably argue. I'm not going to go into too much detail, but if you wanted me to do it, I could give you 15 points.
Okay, thank you very much. You wanted to come in briefly?
Well, I think this basically said everything. I just wanted to say that this case has been looked at very, very seriously. The issue of injunction was considered long before Ghana took the decision to go to the tribunal. Ghana did not want Ivory Coast to get there first, because Ivory Coast could file for temporary measures, and that could operate as an injunction against oil companies.
I asked you that question first. You didn't answer.
I didn't want to
answer. You're answering now.
I didn't want to answer that question because there are a lot of things. I mean, it's a strategy, and sometimes you don't display all the strategy.
I appreciate your difficulty. Okay. Mr. Ekwetu, what would you want to say briefly so that we will move on from this point?
Oh, I believe that in a nutshell, we've all agreed that this is the best way to go. We are prepared, as Mr. Mfojo tells us, adequately to get this thing off. We'll leave the tribunal to take a decision, but we want to put up a good case, make sure that all the facts and the law that will be applicable would be brought before the arbitrators to enable them come to a decision.
Mr. Mfojo agrees with Kweku, just like Mr. Fuseni does, that the rapid response militarily also must be taken care of. You don't overlook that.
I don't think we have any such methods of doing any such things. I don't know how many boats. I don't know. We don't have it. No, we don't have the one with that. No, but the minister is here. Let him tell us.
No, I'm not sure he's discreet.
We are going to sit in cabinet. We hear everything from every ministry. I'm sure we don't have those things.
Well,
we should not worry ahead about it.
Then that is why we must have.
No, but he's told you that should anybody attempt, like
Mr. Eko knows that surprise even this day.
Yes.
It's still an important element of warfare. So you'll be surprised.
And especially in these matters.
No, I don't have a problem. What Mfojo says is this. If the case is pending and anybody attempts to use aggression, we'll go straight to the Security Council. We're going to get some resolutions to ensure that they behave themselves. Otherwise, the whole international community will now,
but you're not suggesting that we will not be able to defend ourselves before we proceed.
We are not. There's nothing to defend.
when we needed, Mr. Ekwetu, when there was a need to fight pair trawling, we found the solution.
So we have some capacity.
Yes, we found the solution. And just not too long ago, the president inaugurated this surveillance, system. Quite an advanced.
No, you see, what I'm saying is this kind of threats cannot be carried into effect.
They are empty?
I don't expect that they will do that. Now, especially so when we are now in arbitration. I don't expect them to go and misbehave anywhere. They won't take it from me.
I see.
Yeah, you see, they might not.
Yes.
But it doesn't mean you should not be prepared to face.
Well, if you have the well, we have, please go ahead.
Okay.
Very cynical.
Yes, very serious matter indeed. Yet, okay. Bonti Benjamin in Achima Buaka says Samson Ghana's decision to go for international arbitration is a step in the right direction. We only pray it yields the desired results for the development of this country. Sofo Yamusa in Kumbungu writes, when will Africans begin to solve their own problems? Are we sure we can even select the other three arbitrators by consensus? It's now clear it is an issue of majority carrying the vote. So how sure are we that Ghana will win the case, particularly when the Ivorians seem to be so confident of victory? Okay, maybe you sent that before you heard Mr. Mfojo and before you heard Aikoto and everybody else. Musa Abato in Kumasi says, Ghana going for international arbitration was the right decision to make. We can at least settle the dispute, which has become an epitome of conflict between both countries. But I want to know what the likely implications. Okay, so you two, you sent it a little ahead. Nana Akwesi Asafueje in Amsterdam says, for the first time in a long while, nationalism and patriotism has been shown on Newsfile. Seeing Honorable Fuseni nodding in agreement to the submissions from lawyer Nia Ikweotu tells us we have a rock-solid support for the arbitration. There are Ivorians here who even think that their country's position is an insincere one. You are echoing Abdul Malik's point. People must know that arbitration is a peaceful redress which is different from the acrimony hardball litigation can bring. God bless our homeland Ghana as we fight for what is ours. Okay, so that is a Ghanaian speaking from Amsterdam. And before we take the break and come to deal with other matters, I almost forgot. And I want Mr. Fojo and Mr. Aiko to classmates. I understand. Nice revelation. I want you to now attempt to also address this for me. When the arbitral award is made, it's final and binding. Does that mean that there is no opportunity at all to make any appeal?
Okay, yes, it is final and binding, and it's final and binding for a number of reasons. Remember that, okay, the way that the international law systems or the international law process around this is structured within the UN Law of the Sea Convention, the objective is to get a boundary by agreement. That's a starting point. Okay. So you do bilateral negotiations first. You must be engaged in them for a reasonable period of time before you kick the issue somewhere else. So you can't have two meetings, then one side goes and says, oh, we've had negotiations, so we're going to, you know, it has to be reasonable. 5, 6, even 10. That's actually part of the reason why we let it go on for some time, because we needed to show that we've done a reasonable period of, you know, attempt at negotiation. Then if that doesn't work, you basically then go to one of the avenues of dispute settlement within the convention. In our case, we go to arbitration for a number of technical reasons, which I don't need to explain here. Now, what the arbitral tribunal is effectively going to do, what the tribunal is going to do, is to do for us what we were not able to do for ourselves. To do for us what we were not able to do for ourselves. And it's really important that this be understood, because if we had successfully negotiated with ourselves, we would have come out with a boundary which is final and binding. The logic, therefore, is that when the arbitral tribunal finishes, that is also going to be final and binding. Basic principle in the dispute settlement system that the Law of the Sea Convention established. Okay. So they will be very conscious of this, which means that they're going to do their work very carefully because they know that it should not be disturbed.
Okay. What happens to any party who wants to violate an award or the decision of the arbitral tribunal?
Well, again, they are parties to the convention. They are parties to the convention. They signed up to the convention. And, I mean, other people will sanction them for violating a multilateral convention.
Thank you, sir.
Well, basically, there's this general principle of compromising judgments.
Oh.
I mean, where a judgment has been given even to the highest court of the land, and the two parties decide that, hey, it's okay, let's talk. We still want to compromise this matter. I think it's always allowable, and between two countries, you can always have a bilateral agreement as to what you think should be the best way forward. After all, the two of you couldn't agree. There was a third party now comes in and says, this is the way I think the thing ought to be looked at. You can now revisit your former positions and then come to some kind of agreement. So we can always compromise whatever.
Do you agree, however, that all of this process does not in any way hurt our, diplomatic relationships two countries?
I don't think so. That's why I said they are only bluffing.
I see.
We're talking of oil and gas.
I know.
Oil and gas. Even countries can be greedy, not just individuals.
Thank you very much. And Ms. Amfuju almost taking us through a very good lecture. Reminds me of Professor Albert Fair, Joe, Justice Mafosa, and then Megache. They took us through arbitration in school. We'll be right back after this break to deal with another matter still at the UN. The president addressed the UN. We'll look at his fight, Ebola fight, and what we can expect beyond the talk.